Hello, welcome. Thank you for joining us for our 2026 live webinar where we will go over the new laws for 2026 pertaining to property management and landlords. Not nearly as bad as they have in years past, but let's get this going. Let me open up so I can share with you. All right, why is this not doing what I want it to do? There we go. Perfect. Let me share my screen and we'll get this going. All right, again, welcome. 2026 new laws for landlords. First off, let me introduce our team here. I am joined just on the other side of the wall here with a full team that will be working in the chat for you. Definitely get into the chat. Any questions that you have, they'll relay anything to me that needs to be addressed vocally, as well as they'll chat with you in the live chat. We are joined by Jeffrey and Eric, who are the owners of the company, the broker, and the general contractor. I am Richard Gibson. I am the Director of Residential Property Management. It is my job to help landlords to be productive throughout the counties of Riverside, San Bernardino, and Orange County, while keeping the access to good laws and taking care of the tenants. We do have a team of about 10 property managers, several of them. If I go and change the camera there, we do have a few of them next door. Several of them are throughout the area on Zoom, or excuse me, on the chat, chatting with you. So definitely get into the chat and make yourself known in there. Probably the most important people on our team aren't here tonight because they're here throughout the day. They're all of our back-end office staff that really make all of this possible. All right, so how are you feeling tonight? Are you feeling a little concerned, a little bit stressed out? I know I would be. California every single year makes it harder and harder for us to take care of our properties. Makes it harder for you to be a landlord and to do what you need to do to make a few dollars as a property owner. So hopefully by the end of the day here, we'll make you more comfortable, give you a little bit of information, help you to know that things aren't nearly as bad as they could be, and we'll have some basis to move forward on. All right, here's my little disclaimer though. I am not a lawyer. I'm not a lawyer. If something I talk about today sparks and sounds awesome, consult a lawyer. If something I say sounds a little off and a little crazy, consult a lawyer. This is just for educational purposes, help give you a little bit of a basis to start on, and then definitely consult a lawyer with any concerns that you might have. All right, so the plan for tonight. Oh, actually, back up. I'm not a lawyer, but I did invite a lawyer to join us in the chat. Benjamin Yongerai is a great lawyer that he's become one of our go-tos for evictions. So if you have any real estate law issues, definitely reach out to Ben at De Novo Law Firm. All right, so what's the plan for tonight? The plan for the night, I'm going to first real quick go through four laws that are kind of high level. I'll go over those if I can get my iPad open. And then we'll slow down a little bit and go over some individual laws. All right, technology, gotta love it. There we go. Okay, so like I said, four laws we'll go over very quickly, and then we'll slow down and we'll have 6 more laws that we will talk about a little bit more in depth. But at any time you have questions, concerns, definitely get your questions into the chat. And my guys over in the other room will be chatting with you, as well as Ben should be in the chat, and other agents, they're taking care of you. All right, so real quick, before we get started, this is a new YouTube channel for us. We want to use this as a system to get information out to you. So definitely down below, there should be a subscribe button. Click on that subscribe button so that we can have that access to you. We'll be posting lots of information on this YouTube channel. All right, so let's dig in. AB 747. Seven increases the procedural requirements for substituted service, requiring photographic documentation of service, and reduces requirement for vacating default judgments. The stricter procedures for substitute service requires a party to show reasonable diligence by attempting personal delivery of the summons and complaint in good faith on at least 3 occasions on 3 days at 3 different times, and that at least one of the attempts must be made at the dwelling house or usual place of abode of the person to be served. AB 747 originally made it on my list today because I thought it was pertinent to the service of 3-day notices to pay or quit. However, my understanding is at this time that it does not apply. This is specifically for service of summons. Therefore, it will affect service of summons for unlawful detainers. This will likely slow down the process of evictions, so I would always recommend using a proper process server. At WSR Real Estate, we always use an eviction attorney for all unlawful detainers. All right, next up, AB 130. Existing law requires a structural inspection by January 1st, 2026 of balconies, staircases, and other exterior elevated elements for buildings with 3 or more multifamily dwelling units. Under the new law, if the building owner confirms the presence of asbestos-containing material during the inspection process and is unable to complete the inspection as a result, the owner has 9 months to complete the necessary asbestos abatement and 3 months after completion of the asbestos abatement to complete the initial inspection. The owner must retain records confirming the presence of asbestos and its abatement for 3 years after completion of the inspection. This is a pretty specific law that, as far as I know, does not apply to any of the properties WSR manages, but we are still finishing up some of our balcony inspections and are waiting on the reports. Up next, SB 610. I'm not going to go too heavy into the provisions of SB 610. However, there are a few points that I do want to hit. First, it is the duty of the landlord to remediate, as may be necessary, any dilapidations such as removal of debris or the presence of smoke residue or ash that arises as a result of a disaster. Second, the presence of debris at a rental unit, such as ash, sludge, or runoff, is presumed to render the rental unit untenantable pursuant to the statutory habitability standards, unless a public health official has determined that the debris is non-toxic. Third, unless lawfully terminated by either party, the tenancy shall remain in effect, and the tenant shall have the right to return to the rental unit at the same rental rate in effect immediately prior to the disaster, as soon as it is safe and practicable. And finally, even with all of that said, the landlord is not required to rebuild a residential rental property or any portion thereof that has sustained damage as a result of a disaster. And finally, AB 1414. AB 1414 is pretty short and sweet. I'm just going to read the whole law. It says, a landlord of a dwelling shall not require a tenant to subscribe to a specific internet service provider. If the landlord violates subdivision A, the tenant may deduct the cost of the subscription to the internet service provider from the rent. Perfect. So that's where we're at. Those are the first 4 laws that we're going to run down real quick. Let's take a quick look at our communication here. Doesn't look like I've got any questions going on quite yet. So we will keep moving forward. So let's go on. Algorithm. AB 325 updates the state antitrust rules to deal with something called a common pricing algorithm. That means any software or technology used by 2 or more organizations that takes competitor data and uses it to recommend or influence prices. In our world, that would include tools that suggest rent amounts based on what nearby landlords are charging. The big change is this. It's now illegal to use or distribute a common pricing algorithm if either of these happens. 1, it's part of a contract or agreement that restrains trade. Basically, anything that could start to resemble coordinating pricing among housing providers. 2, a person pressures or coerces another landlord to use the algorithm's recommended rent or lease terms for similar properties in California. In other words, if a pricing tool gathers competitor information and pushes everyone towards the same rents, and especially if companies are pressured to follow it, AB 325 says that it is illegal. Because this expands what counts as illegal under California's antitrust laws, violations can carry serious legal consequences. What this means for landlords: you can still use market data, comps, and analytics, but you'll want to understand how your pricing software works. If it uses competitor data and encourages uniform pricing across multiple landlords, that could cross the line under this new law. Bottom line, AB 325 is aimed at preventing algorithm-driven rent coordination. My question is how this affects pricing algorithms like Zillow's Rent Zestimate, Rentometer, Rentcast, or any of the other rent comp services. Like I said, we can still use comps, but using these other systems might be a concern. We will have to see how these systems adapt. Perfect. So that's kind of an interesting one. We'll see how that comes together as these algorithms, come together and try to figure out how to work with the new law. All right, up next, AB 723. Digitally altered photos. A real estate broker or salesperson or person acting on their behalf who includes a digitally altered image in an advertisement or other promotional material for the sale of real property shall include in the advertisement or promotional material a statement disclosing that the image has been altered and a link to a publicly accessible internet website, URL, or QR code that includes and clearly identifies the original unaltered image. The statement must be conspicuous, located adjacent to the image, and indicate that the unaltered image can be accessed through the link. If the advertisement is posted on an internet website over which the broker or salesperson or person acting on their behalf has control, they may alternatively include the unaltered version of the image. This law applies to images altered with photo editing software or AI, but does not apply when only common photo editing adjustments are made. So, what does that mean? Any digitally altered image used in an advertisement or other promotional material for the sale of real estate must include 1. A reasonably conspicuous statement located on or near the image stating that the image has been digitally altered. 2. A link to a publicly accessible internet website, URL, or QR code in which the original image is clearly identified. And 3, the statement must also indicate that the unaltered image can be accessed at the link URL or QR code. If the digitally altered image is posted on a website controlled by a broker or sales agent, they may comply by either including the unaltered image in the posting or by including a link, URL, or QR code that clearly identifies the unaltered image. So if we post images that have been digitally altered, then we have to mark the photo as digitally altered and provide a place where they can view the unaltered image. For us, that would most likely mean that we would post both the altered and the unaltered photo consecutively in our online marketing. So what does digitally altered image mean? An image created by or at the direction of a real estate broker or salesperson or person acting on their behalf, altered by photo editing software or artificial intelligence to add, remove, or change elements in the image, including fixtures, furniture, appliance, flooring, walls, paint color, hardscape, landscape, facade, floor plans, and elements outside of or visible from the property, including but not limited to street lights, utility poles, views through windows, and neighboring properties. Digitally altered images does not include images where only lighting, sharpening, white balance, color correction, angle, straightening, cropping, exposure, or other common photo editing adjustments are made that do not change the representation of the real property. Does this law apply to leases? Only if the lease exceeds 1 year's duration. How does this apply to you or WSR as a property manager? Its effect is probably fairly limited, as we typically do not market leases greater than 1 year, and we currently do not use a whole lot of digitally altered images. However, this is obviously the way things are moving. The purpose of the law is to ensure that photos are not false advertising. As such, we will do our best to ensure that we are representing our properties accurately and in accordance with this law. Excellent. So 723 is pretty basic and really is about realtors and our side of things. However, I can very well see that it's going to go out to all marketing, and we will definitely, follow the law, do what we need to do. Let's see, any questions so far that we can answer? Looks like we are doing pretty good, and we will keep moving forward. So moving on to AB 246. If a tenant cannot pay their rent due to an interruption in the payment of Social Security benefits, the tenant may assert an affirmative defense to an unlawful detainer based on non-payment of rent. This law permits a tenant of residential real property until January 20th, 2029 to assert as an affirmative defense in an unlawful detainer action for non-payment of rent that they experienced a loss of income due to an interruption in the payment of Social Security benefits due to the action or inaction of the federal government. When the tenant provides evidence to the satisfaction of the court that the benefits have been terminated, delayed, or reduced due to the no fault of the tenant, and the interruption in Social Security benefits prevented the tenant from paying the unpaid rents, upon the tenant proving such Social Security hardship, a judge in an unlawful detainer must issue a stay of the proceedings until 14 days after the Social Security benefits are restored or after 6 months, whichever is earlier. This law does not relieve the tenant of the obligation to pay their past due rent. Once the Social Security benefits have been restored, the tenant is obligated to either pay all past due rent or enter into a mutually agreed upon payment plan with the owner, after which the unlawful detainer case is dismissed. All right, we there? Yep, it looks like we're back on. Sorry. So AB 246. Any questions about AB 246? I think we're doing okay on the questions. Moving on. AB 414. Now we're getting into some that are actually pretty pertinent. So let's move on to AB 414. Electronic return of security deposits. Existing California law details how a security deposit is handled after the tenant moves out. Current law dictates that any remainder of the security deposit shall be refunded by check payable to the tenant. However, if agreed in writing, the security deposit may be refunded electronically or by any other means available. AB 414 flips that around. It simply changes the default method of refunding the remainder of the security deposit. By default, security deposits are to be refunded electronically if the deposit or rent was paid electronically. But if agreed to in writing, the deposit may be refunded by check or any other means available. The exception to the electronic return of security deposit is if there is more than one adult on the lease. If there is more than one adult on the lease, then any refund of the security deposit will be made by check payable to all tenants. AB 414 also requires that within a reasonable time after notification of either party's intention to terminate the tenancy, the landlord must notify the tenant in writing of the tenant's right to receive the security deposit electronically. This law applies to the original landlord as well as any successors. AB 414 did not change the way that the itemized statement of security deposits is handled. It is still required to be sent by first-class mail unless the tenant agrees in writing to receive it electronically. For those of you whose properties are managed by WSR Real Estate, we already have this capability in place with our management software. All we still need to do is update our notices that go out after a tenant gives notice of termination. Excellent. So this is actually pretty important to us. How we return our security deposits. It needs to be in conjunction with the law. But the systems are already there. Easy, not a big deal. It just flips around what the default system is going to be. All right, do we have any questions that need answering? We're looking pretty good. Looks like my guys are working in the chats with you. Hopefully we're all going well. There is a question. They want a little more information about SB 246. So let's go back to, I guess it's AB 246. So let's go back to that real quick. What this is if a tenant stops receiving their social security benefits and therefore cannot pay the rent, if they stop receiving those benefits because of a government shutdown, because of that type of a situation, we can't evict them for that. The judge can delay that for up to 6 months while the government gets their act in order and can get some information back out to, or get that money flowing again. It does not stop them from having to pay the rent. It just delays that. So if we go into an eviction process and they get delayed 6 months, then the judge can still come back and put a payment program into place or pay the balance of the rent as soon as the money starts coming in again. Let's see what else. AB 610. AB 610 has to do with the balcony inspections. Oh no, balcony. Oh no, AB 610. That's the remediation. No, it does not have anything to do with any size. A single family home, the owner is responsible for remediating any issues after a disaster. All right, anything else? Perfect. Moving on. All right, the last two are actually quite pertinent to us. SB 655, although is kind of, we're going to see how things are coming together over the next couple of years. No big issues yet, but let's go ahead and go over AB 655. All right, where's my iPad? All right, AB 655. AB 655 declares that the established policy of the state is that all rental dwelling units must be able to maintain a safe maximum indoor temperature. Beginning January 1st, 2027, various state agencies must consider this policy when revising or establishing regulations. The established policy of California is that all residential dwelling units shall be able to attain and maintain a safe maximum indoor temperature. All relevant state agencies, including but not limited to the California Environmental Protection Agency, Department of Housing and Community Development, Office of Land Use and Climate Innovation, Public Utilities Commission, State Energy Resources Conservation and Development Commission, State Air Resources Board, State Department of Healthcare Services, State Department of Public Health, and Strategic Growth Council shall consider the state policy when revising, adopting, or establishing policies, programs, and criteria, including grant criteria that are relevant to achieving this state policy. and beginning January 1st, 2027, when revising, adopting, or establishing regulations that are relevant to achieving this state policy. This law establishes the policy of having a safe indoor maximum temperature, but does not specify a precise temperature that would qualify as a safe indoor maximum temperature. Moreover, even though the law goes into effect on January 1st, 2026, the requirement for agencies to consider this policy in revising their regulations does not begin until after January 1st, 2027. And even then, those agencies are required only to consider the state policy. In terms of habitability, this law is codified as Health and Safety Code 17914. Had it come within Health and Safety Code 17920.3 or 17920.10, it would have been directly incorporated into the statutory habitability standards for which the standard tenant remedies would be available, such as rent withholding, repair and deduct, or vacating the premises. Without that reference, a tenant's remedy for the landlord not maintaining a safe indoor maximum temperature would be based on the more vague claim of breach of warranty of habitability. So, SB 655, so far is a bunch of nothing, but it shows us where things are headed. Over the next year or two, agencies will develop regulations in accordance with the new law. But for now, nothing new that we have to do. Excellent. So SB 655 just shows where we're going. We're going to have to be providing air conditioners, I'm sure, in the next couple of years. The vast majority of my properties already have air conditioners, so I don't think this is going to be a huge deal, but it is definitely something to be paying attention to if you have properties that do not have air conditioners in them. All right, looks like questions are being handled well in the chat. Let's keep that going. Let me see if I've got anything here. Who determines what temperature is safe? So far, that has not been determined. See, that's part of the problem with this law, is the law does not specify what a safe temperature is. So all of those government agencies will take into consideration over the next year or two what regulations they want to put into place. And over those next couple of years, they will figure out what they're going to have to identify what that number is. It's got to be a number. Obviously, what you're comfortable in is different than what I'm comfortable in. What I'm safe in is definitely different than what a 95-year-old, frail little grandma is safe in. So they are definitely going to have to be more specific on that. But at this point, there's no specifications, very little information. We just got to know that it is coming. All right, excellent. Anything else in the chat? I think we're looking pretty good. Let's go on to our last one. And this is probably what everybody is concerned about. And refrigerators and stoves, AB 628. Stoves and refrigerators. Current California law states a dwelling shall be deemed untenantable if it substantially lacks any of the following affirmative standard characteristics. And then it goes on to talk about weatherproofing, plumbing, water supply, heating, electrical, and so on. AB 628 adds a working stove and refrigerator to the list of habitability requirements. AB 628 requires the landlord to provide both a stove and a refrigerator maintained in good working order and capable of safely storing food as a condition of habitability. Neither the stove nor refrigerator can be subject to recall, and if the landlord receives notice of a recall, landlord must replace the stove or refrigerator within 30 days. The tenant may supply their own refrigerator. A tenant and landlord may mutually agree when the lease is signed that the tenant chooses to provide and maintain their own refrigerator, if all of the following four conditions apply. 1, The lease contains a statement in substantially the following form. Under state law, the landlord is required to provide a refrigerator in good working order in your unit. By checking this box, you acknowledge that you have asked to bring your own refrigerator and that you are responsible for keeping that refrigerator in working order. 2, the lease provides that the tenant may, with 30-day written notice, inform the landlord that they no longer wish to keep their own refrigerator in the unit, and that at the end of the 30-day notice period, the landlord shall install a refrigerator in good working order in the unit. 3, a landlord shall not condition a tenancy upon the tenant providing their own refrigerator. And 4, the landlord shall not be responsible for the maintenance of a refrigerator provided by the tenant. The requirement to provide a refrigerator and stove applies to leases entered into, amended, or extended on or after January 1st, 2026. So, does this apply to month-to-month rental tenancies once rent is accepted after January 1st? This law applies when a lease is entered into, amended, or extended on or after January 1st. Month-to-month tenancies are deemed renewed on a periodic basis per California Civil Code. However, they are not typically characterized as extended. The use of these words renewed and extended in various Civil Code sections indicate the legislature's intention to ascribe to them distinct meanings. Therefore, the requirement of this law to provide a refrigerator and stove, which apply to a lease that is extended on or after January 1st, would likely not apply to a month-to-month tenancy unless it was either amended or it was newly created on or after January 1st, 2026. Therefore, the law applies to a month-to-month rental if the month-to-month agreement was amended. For example, any change in terms of tenancy, including an increase in the rent, would likely constitute an amendment necessitating compliance. However, the law does not specify the size of the refrigerator. It only states that it must be capable of safely storing food. It does not have to be new, nor does it have to provide water or ice dispensing or any other amenity. It does not have to be nice. It just has to be able to safely store food. All right, so this, like I said, this is the big one. I left it to the end because of I presume we're going to have all the questions about this one. I know we've already getting questions about the size. The law does not specify what size it has to be. It just has to be able to safely store food. I would say a little 6-pack refrigerator, Coca-Cola 6-pack refrigerator probably isn't sufficient. It's not going to suffice to the level of the law. However, a little hotel refrigerator might be something that is, fulfills the requirement of the law. If you've got a $3,000 or $4,000 a month rental and they want a refrigerator, they're going to get something basic, right? They're not going to get the nice stainless steel with water and ice and whatever, in the door. So I don't see this as nearly as big of a deal as what we are fearing that it might be, but we do have to provide refrigerators. Stoves, we're already doing that. At least WSR is doing that in pretty much everything that we've got. So that's definitely not a big deal. Refrigerator is kind of the new thing. All right, let's see. Any other questions? Looks like we're doing pretty good on the questions. No, perfect. We'll come back. We'll take some more time. Let me move forward just a little bit, and we'll come back if there's any questions that we need. So to recap, laws are constantly changing. You definitely got to be out there and paying attention. We are here definitely trying to help landlords across the board to make sure that they are doing things legally. but the laws constantly change and are getting more difficult to take care of and keep up to date. For those of you who are our WSR clients, we're definitely here. We're taking care of it. We got our eyes on it. If you are a realtor joining us or property manager, California Association of Realtors, all of that, the information is out there. Definitely need to keep up on top of that. One of these guides that I really like, the California Tenants Guide, there's a QR code there on the screen. That is very helpful. But the problem is the laws are constantly changing. So I don't know if that form is being updated as quickly as the laws are being updated. But I definitely like that little booklet put out by the court system. All right. So we're starting to wind down. We'll definitely still have some more Q&A if there's some cute questions that need to be answered. But I hope your time was worth it. I hope you got a little bit of information, settle a little bit of concerns. But if you still need a little bit more help, we are still got some Q&A coming. But if you are a WSR client, definitely reach out to your property manager. Your property manager is being properly trained on all of this. And if they don't know the answer, we will find it out and we will make sure that you are taken care of. Any property owners, that is my cell phone number on the screen there. I am more than happy to have a conversation with you. And if you're a realtor or a property manager, we do pay for referrals for management contracts. So reach out to me if you have any questions on that. All right, one last time, down on the bottom there, please click on subscribe so that you don't miss any of our new videos. All right, last round of questions. Any other questions that we've got in here that we need to answer? All right, important question there. Let me see real quick. All right, two questions about the refrigerators and when does that kind of go into place. One question is, if a current month-to-month tenant has their own refrigerator and it dies, we are not required to provide one unless the rental agreement has been amended. That is correct. Until the rental agreement is amended, then there is no requirement to provide a refrigerator. Now, what constitutes an amendment? One of the questions here is if a rent increase constitutes an amendment. Yes, if you increase the rent on or after January 1st, that does constitute an amendment of the existing contract, and that will trigger the law going into effect. All right, what else? Going back to the safe maximum temperature wall ACs. Currently, there still is no form to this law that we have to deal with. But yes, wall ACs, window ACs, mini splits, anything that has to or that is capable of maintaining a safe maximum temperature can be used. There's going to be lots of opportunity to mini splits is probably going to be one of the biggest things. They're efficient, they're inexpensive, relatively inexpensive, and relatively easy to install. So I think we'll see a lot of mini splits going in. But yes, a wall or air conditioner will also suffice as long as it is sufficient to keep that temperature below whatever the legislature finally decides is required. All right, what else? Does the stove change any of the regulations for ADUs? Only the fact that it requires a stove. That would be the only thing that I could think of. I don't know why it would domino into anything else. Perfect. Anything else coming up? Team WSR. Here we go. What do we got here? So, do we need to go to each tenant and ask if they want us to provide a refrigerator? No. It's only triggered that we have to provide one if they come and ask us for one, right? In as we are doing rent increases, as we are doing whatever amendments that trigger this, we are going to have to disclose to them that this law exists. Though, like I said when I went through that, there's going to be a little paragraph saying that California law requires that we provide a refrigerator. You have deemed chosen to bring your own. But with a 30-day notice, we are still liable for bringing in a refrigerator. So that is where it's going to be. They have to ask for it. We do not have to go and offer it per se. However, in our disclosures, we're basically going to be offering it as we are doing those rent increases, as we are renewing leases, as we are doing things that amend their tenancy. All right, anything else? I'm not seeing anything coming up per se in the chat. So let's give it another second or two. Anybody have any questions that we can answer for you? Again, reach out to me. Reach out to your property manager directly. Reach out to me. You can get a hold of me here. Again, here's my cell phone number. If you don't have a property manager here at WSR, you can definitely reach out to me directly, and I would be more than happy to work out anything with you that you need. Let's see, last run down the chat here, see what we've got. Thank you, Eric. You just put my email address in there in the chat. Yep, reach out to me. Reach out to me. Email is fine as well. Perfect. Thank you again. Be sure to click subscribe down there, and so you can get all of these videos on YouTube. And thank you for joining us tonight.